Well, first, I just want to start with the point of having this provision. It's in Florida statute. I just want to say it's your right under Florida law. So if you do ask records, going through the correct ways to do so from your association, they're not doing you a favor. You're simply just exercising your right. And the importance of the record keeping and the record inspection process is simply transparency. You are allowed to know how your money is being used. You're allowed to know what's going on at, behind closed doors, board meetings, the finances, what your association is spending money on, how are they maintaining the association, communications. So Florida has these statutes similar in HOA and as well as co-ops and other similar entities, where if you send a written request, certified mail, with the actual items that you want to inspect, once the association receives it, they have 10 business days to provide a date and time for you to come and inspect the documents.
I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of L.S. Carlson Law. Welcome back to the show, Bad HOA. Today, I have my producer, Marty.
Good morning. Thanks for having me. It's always fun.
Welcome back. And a very special guest coming from Florida, our partner, David Lehr. How are you?
I'm doing well. It's nice to see you both.
Nice to see you, and thanks for joining us.
Oh, my pleasure. Always excited to share what's going on in Florida and how we can help out owners.
Well, there's a lot going on always in Florida. And today, I really love the topic because it's so impactful for condo owners and really empowering them in the space. And specifically, we're looking at condo record keeping requirements. This is massive. It has massive impact, and it is a very, very powerful tool that a lot of owners have, but they have no idea that they have it. Would you say that's accurate, David?
It is. From my experience, owners don't know it exists. They ask how to get more information when there are mechanisms in place that they can simply just exercise. It's their right to do so.
And I bet you that this has changed greatly over the years with the advent of digital, file keeping. That there's probably laws that have changed significantly over the years, and that might have impacted what would have been your bylaws or CC&Rs.
The accessibility of the documents.
Yeah.
David, where do you want to start with this? Because it's a broad topic to some extent, but it's also a very narrow topic because we're looking at one thing. So where's the best starting point? How should we frame this for a condo owner who's watching the show, who saw record keeping, and they said, yes, I need records because I have a really bad association? Where do they start? Or how do you want to start?
Well, first, I just want to start with the point of having this provision. It's in Florida statute. I just want to say it's your right under Florida law. So if you do ask records, going through the correct ways to do so from your association, they're not doing you a favor. You're simply just exercising your right. And the importance of the record keeping and the record inspection process is simply transparency. You are allowed to know how your money is being used. You're allowed to know what's going on at, behind closed doors, board meetings, the finances, what your association is spending money on, how are they maintaining the association, communications. So Florida has these statutes similar in HOA and as well as co-ops and other similar entities, where if you send a written request, certified mail, with the actual items that you want to inspect, once the association receives it, they have 10 business days to provide a date and time for you to come and inspect the documents. And Florida has already given you a list of items that you are entitled to view. I say finances because that includes, balance sheets, account statements, everything along those lines. Of course, the governing documents. So if you're unclear about updated rules, the covenants, bylaws, that is also within the statute that you're entitled to inspect. Among other categories, invoices, contracts, especially between the association and property management company. Say you're unhappy with the property management company, you want to see what they're actually contracted to do. Or if you're a new board member, you want to get rid of them, you look at the contract and you see, hey, do I have to send a notice of termination, or can I terminate with or without cause? So having these documents codified in the statute is important for owners and even board members. And there's also a catch-all provision, which says, to the extent not listed above, which, above is the statute. Nobody wants to be, using a magnifying glass going through the inner workings. But it says to the extent not listed above, but has to do with furtherance of the business of the association. So the statute allows for a wide net of categories of documents that you're entitled to see. I mean, basically, everything except for, privileged communications you're not entitled to, whether your neighbor has a service animal, that's no one's business. Personnel records, that's off limits. But for the most part, the statute allows people to hold the boards in check, to analyze ballots following an election, or even voting for an amendment to your covenants. So it's really important to have transparency. I tell clients, it's your right to have the same information, obviously with some limitations. So you should exercise your right. And you notice through this process, we're talking about inspection. You're not really there to, make copies. I mean, if you make copies, or if the association makes copies for you, they can charge. So over the years, Florida has included additional aspects within the statute that allows you to use, your smartphone that has a scanning device, or you order something off Amazon that's like a portable scanner. So as it is now, before the new laws are in effect, basically you send the written request. They respond within 10 business days.
Well, yeah, David, just briefly on that. Let's walk it through. Let's walk this through mechanically, because I think that's helpful. So I'm an owner, and I'm furious with my bad COA, condo association. And in order to back my position, I know the association has records. So what is step one? I know I have to send a notice. I have to send something that demands. And are we talking about an email? Is this on a typewriter? What are we looking at here?
So under the statute, you need to send it certified mail.
Okay.
Return receipt requested, and that's important because, as I mentioned, they have 10 business days to respond.
Now, briefly, who am I sending it to?
So
who's the recipient?
I send mine to the registered agent of the association. The registered agent is the individual or entity tasked to receive official correspondence on behalf of the corporation, which is the association.
Now, how do I find that? How do I find that person?
That's the question.
So you're going. Your legal mind is working brilliantly, but sometimes we got to sort of take it step by step. So you're saying, okay, I prepare it, I print it. It's a demand that lists the documents that I want. I'm sending it to an agent for service of process. How does one find the agent for service of process?
So at least in Florida, you can go to a website called somebiz.org.
Okay.
That is a website run by the Secretary of State of Florida. Basically, if you have any corporation, LLC, you need to register with the Secretary of State.
Okay.
That is what condos have to do.
Public information.
So basically, public information. Absolutely. It's at no cost to you. Anyone can go look at it, even if you're not a member of the association. So you type in your association name, Luke Carlson Condo Association, Inc. You type it in, and then you go down and see, it should have the officers of your corporation or the board members.
Okay.
And then it should have a separate area for registered agent. So that's where you should send it. Some people send it to, the property management company. Sometimes they're not the registered agent, so it could get lost in the shuffle. But the registered agent is designated as the official receiver of the official correspondence.
Okay, so we fire this off.
Would you recommend, David, too, because my immediate concern when I hear this is going to get lost in the mix.
Okay.
Would you recommend also emailing someone that you know on the other side, just so you're aware I've requested this through certified mail, just so you have more trail to the request?
So it's the
Because I'm wondering,
belt and suspenders.
it's going to a registered agent, and in my mind, I immediately think, oh great, it's going to go to some property manager, it's going to go somewhere, and then it's going to go to some clerk. I'm never going to get this
response.
I'm never going to get a response to. That's where my head goes. In your opinion, would you also recommend a secondary correspondence to say, I've requested this through the law X, Y, and Z, and I'm anticipating a response?
Well, let's unpack that. So first, yes. Simple answer, I would recommend emailing it, whether it's the property manager, if you know a board member, or even if you have email communications with the board attorney. That's always good to cover your bases, but you still have to mail it to satisfy your duties in order to get them to respond timely and keep a track of the number of days. So even if you email it to them, the clock doesn't start until once they receive it in the mail.
Understood.
But I think it's always good to do both if you can. Ideally, if it's a property manager, they're a licensed community association manager, they'll know what to do, or even attorney's office, even better. But people are human. Things get lost in the shuffle, so it's always good to cover your bases to make sure that it's being received, analyzed, and responded to.
And David, what about this? I mean, I'm assuming at this point, if someone's going through the legal way of requesting documents, it's to the point of contention. Right? Well, could you just request it? Just walk into a board member and say, hey, I want to see X, Y, and Z. And they can say, sure, come on by and you can look at it. Do you have to go through the formal process? Or is this to the point where I've requested it, I've gone through just the informal channels and no one's responded to it, so now I'm going to go through the formal channels? Is this a ratchet up in aggression? Or is this just the standard protocol you would say to take?
Well, ideally, if you email your property manager or board member, or just, in passing, you see them, getting the mail, it'd be nice if they would respond, but to the extent they don't, there's no repercussions.
Sure.
So that's why you send it certified mail, return receipt requested. That's what the statute says, because, once they receive it, they have 10 business days. And if they receive it and say, you can't come look at it, or you can come look at this, but not this, even though you're entitled to look at it, then they can be subject to penalties.
Or they ignore it, right?
Or they ignore it, yes. Well, even if they ignore it, you do want to follow up, because if you're doing a records inspection request, you want the information. So I still recommend following up. And to the extent they still ignore it, despite your best efforts, they could be subject to penalties.
Excuse me.
Penalties by way of fines?
Yes.
Well, let's get into that, because I think that's a fun area.
Yeah.
So we send it, homeowner sends it, and it's ignored, or I'm sorry, maybe not ignored, rejected, just rejected. Nope.
They
sorry,
say no.
No dice. What are the fines? What does that trigger legally in terms of a right by the owner?
Yeah. So at that point, they're in willful violation of the law. And that's the distinction. If they, I mentioned the 10 business days, if they answer on the 11th day, no big deal. It's not really a gotcha. To be in violation, to go to the next step, it has to be willful.
Okay.
Knowingly violating their obligations under the statute. So at that point, you have a couple of options. You can submit a complaint to the DBPR, Department of Business Professional Regulation. They can open up an investigation where they would fine your association up to a certain amount. Of course, there's limitations. $50 a day for up to 10 days. And they will have to be forced to provide the documents. So
right.
If the association doesn't want to do it, and they're like, oh, we'll just pay the fine. That's not how it works. They still have to go forward with disclosing the documents. And I know some people, and I get it, are worried about, well, do I have to get an attorney and pay for fees? Yes, it would be better. But in this scenario, the DBPR will order the association to pay your attorney's fees.
So they become the enforcement arm on your behalf to not only
Right.
fine and punish but also to procure the documents you were looking for in the first place.
Yes, absolutely.
Okay.
But I will look towards the DBPR, not necessarily going straight to litigation in circuit court or some other venue, because it would be faster, and it's part of their scope of what they do.
David, what's let's just say they do respond and they provide you the documents that you want, and part of it's redacted.
Well, it depends what's redacted. So say I ask for the billing entries of the association's attorney. Well, they can redact some of that. That's privileged communication, but I can see how much was spent and the retainer. If I ask for sensitive information when they redact social security numbers, sure, they can redact it. If they're just redacting because they don't want the member to know something, well, that's where we have an issue. So of course, in that situation, you don't quite know what's redacted, so you may want to reach back out to them and ask, what is redacted and why. And then from there, you can decide the next best option would be to escalate, push back, or be satisfied with the answer.
David, so thank you for walking us through sort of when they, you have that sort of bad faith response, no, and what to do in those circumstances. But let's run a course now where you follow the law, you send the demand, they respond favorably. They say, yes, you can inspect. Now, what does that process look like? Can you walk us through that?
Yes. So they have to provide a date within 10 days. If that's not convenient for you, you can schedule a date, outside the 10 days. They satisfy their obligations.
Can they supply a date that says, okay, we'll supply a date in 2 years? Like I'm just throwing it out there. I have no idea.
Correct. I mean, can they play games, I suppose, with the scheduling is the question, I think.
Yes and no. So you have to provide a date within 10 days. So a lot of times you receive correspondence from the association saying, you can come tomorrow at 9 a.m. Okay, so they satisfy their obligations, but who can clear the calendar, get a babysitter, get off work,
right,
fly down here, wherever you are, to do the inspection the next day. So in that case, they are satisfying their obligations in the statute, but it's still a little bit unreasonable for someone to, cancel everything to go forward with it, that last minute. So in that situation, I tell clients, try to make it if you can, really do your best to find a way, get an agent, someone with authority, or depending on the association or even, the attorney that we may have a previous relationship, we can reschedule it. So they can't really put it off for 2 years. They have to respond within 10 business days. But sometimes there's some gamesmanship involved with that too.
Understood. So at that point, though, let's say it's calendared, you can make it, and you're showing up physically, correct? This is a physical inspection. What format does it typically take? I mean, are you showing up in a room full of records and you're just sitting there going through it? Is there a laptop in front of you? What is the mechanics of this? So
that's an interesting question, because that's what the state of Florida is trying to change, because it's right now it's not uniform. It's really specific to that association. Some associations, it's all electronic. You can go there, bring a flash drive. It's simple exercise. Some, keep all their documents in banker's boxes.
Okay, I was going to say.
Really, keep records. So in that case, you're going to perhaps a room at, the attorney's office or property manager's office, and you're just going through banker's boxes. So it really depends. It'd be nice to know ahead of time. So I don't see any harm in asking how they, maintain their records, because if it's electronic, of course that makes it easier.
Right.
If it's all physical, you're going to want to bring your scanning device, chargers, notepads, really everything to make sure it's done in an organized and efficient manner.
Now,
does
go
the
ahead,
law
Marty.
specify that you have the right to make copies of those records, or what if they push back and say, "Oh no, you can look, you can't take photocopies or you can't take or even digital copies of it, can't email it to yourself, but you can look." Does he ever get in that situation? What does the law actually say?
Yes. So the statute does specify you're allowed to use electronic devices to assist in the inspection process. But if you do want copies, the association can charge you, 25 cents a page.
Now, is that them? Sorry, is that them producing the copies for you, or are you, copying it yourself and they're somehow upcharging you, right? Who's copying it? I know it's a odd question, but I do wonder how that actually works logistically. I mean, you show up, you say, yes, I need copies of this. And they say, here you go, here, make copies.
No, we'll make a copy. You owe us $3.
Yeah. How does that actually work, David?
That's how it is. So if, for example, if you're at a property management company's office, if you want to make copies using their copier, they can charge you 25 cents a page.
Okay.
That's within the law.
But if you bring your own printer
copy
with
machine?
No, I'm serious. I mean, printers are not that big.
Yeah.
So you bring your own printer and you can run through copies. They're not compelled. They can't charge you for your own copies.
Sure, but at that point, if you're able to print and email them to yourself, you probably don't need to copy them there.
Yeah.
But depending on what you're after, you may say, I don't even want to do the inspection. Just tell me how much I would owe for these 4 pages of documents that I'm requesting. But for someone who wants to go through the finances or, meeting minutes, violation notices for the past, 7 years, it might be good to have your own device on hand.
Let me ask let me paint a scenario. So you show up, you're, let's say, in the management company's office, and they say, go at it, here's all the records, and you're hit with 50 banker boxes. And you're looking for one key document. Let's say it's a vendor agreement. Is the burden on you to sift through the 50 bankers boxes, or is the burden on the management company, or really the association, to produce the one document that you're looking for?
So, ideally, the association, if you want one document, you specify it and they produce it. But again, it depends on the association. If they're disorganized, where they just have boxes full of, contracts, invoices, and maybe it's organized by year, or, by, scope of work, then it's up to you. They have to be reasonably organized. Of course, that's very subjective.
Right.
But, I don't think if you're after just one document, I would ask them to just provide it and you pay the 25 cents for the copy at that point.
Understood. And then I guess the follow-up question to that is, let's say you are on a fishing expedition where you're going through all these documents or all these boxes. What's the time frame? How long do you have to actually go through, and actually find the document you're looking for, assuming a level of disorganization and volume exists?
Well, the association can impose, time limitations. It really shouldn't be a large undertaking. Otherwise, you just have to come back another day. They don't have to keep, the office open past normal business hours. If they break for lunch, they break for lunch. They're not going to open at 6 a.m. for you to get ready. Ideally, the inspection shouldn't take you so long because when you're at the inspection, you're not just reading every single word. You'd be there all day.
Right.
You're kind of seeing what the document is and capturing it. Depending on what you're after, it could take a few hours. If the association is wanting for you to leave for whatever reason, they have to close up, or it's just way too much time that you're spending there. You just have to come back on another day.
David, is it your right to say, I want, let's just say that you want the kitchen sink. You want every document that you're entitled to, period, for the last 7 years, because you don't trust your HOA for whatever reason. I know this is an atypical scenario. Let's say I want balance sheets, I want P&Ls, I want everything that I'm entitled to. I want minutes. I want everything. And so number one, are you entitled to everything all at once? And to the extent that you are or aren't, do they have to supply everything for you? Or they just say, here it is, go for it? I mean, that's kind of wrapped up into Luke's original question.
Yeah, so you're entitled to everything at one time. But with that said, it's difficult for the association to gather everything, and they can charge time for getting the records ready for inspection. If you're going back 7 years, maybe these records are kept off-site in a storage facility. If they have to pay to remove it, you could be on the hook for that. So to the extent you want to do an inspection and you want 7 years, I'd be as specific as possible. But certainly you have the right to ask for it. They can charge you to gather it without making copies even.
Is there a standard for that charge? Is that specified in the law, or is that kind of a gray area that's subjective? They can't charge $600 an hour to gather documents. I have no idea.
Yes, no, it is limited to $20 an hour. And of course, I always tell clients, to the extent they want to charge you, we're going to ask for an invoice ahead of time to see how long it would take, and then from there perhaps you can narrow it down. But associations can limit the number of requests you can have, where the location is, things of that nature. Not necessarily the substance, but more about the procedure. So some associations say you can only ask once a quarter, once a month. It just depends on the association.
So, David, my question is this, and I think this is a very relevant question because the show, the podcast, we really try to empower homeowners to enforce their rights against a bad association. And because this is a tool that an owner can use unilaterally, meaning they don't need an attorney, when would you say it is appropriate for the owner to do it and drive it on their own? And what is the tipping point where they say, you know what, an attorney should come in, an attorney should assist with this inspection? How do you balance that? And what advice would you give, especially when it comes to what is the benefit of having an attorney lead the charge and lead the inspection?
Well, I think tipping point whenever you want to go forth the inspection is, is there something going on that behind the scenes that maybe there's some distrust there? Or is my board being transparent? Are they telling me one thing is actually going on? Let's look at the empirical evidence, the actual data. And if there's any sort of unanswered question, I recommend doing it. Everyone should have the same information as I mentioned. As far as whether the homeowner wants to do it or have an attorney, I think it depends on each homeowner. First, I'd recommend reading about the process. I don't think it's a large undertaking, but maybe some people aren't comfortable with it. So first, understanding, are you capable of doing this? Do you want to do this? Do you want to take time off work? Do you want to find a babysitter or fly down? If you think you have an association that, doesn't really listen to owners, you feel like they've buried the head in the sand in the past, ignored requests, general distrust, perhaps you do want to hire an attorney. First off, the attorney, knows the law, they'll be efficient with their time and get straight to the point, won't accept no for an answer.
Well, I always see it too. When the lawyer gets involved, it's a different situation entirely. I mean, you are bringing a strong advocate to the table. A lot of the Mickey Mouse gamesmanship goes away, and the owner is sending a very strong message to the association that you talk about ratcheting it up, right?
Yeah.
I mean, this is okay. Now we've actually brought a serious player to the table. So have you seen that in your experience and your involvement?
Absolutely. So owners, once they retain us to do the inspection, among other things they want us to do, they've reached the end of the rope where the back's against the wall. They're not being listened to. Perhaps they're being bullied, and there's nothing better than fighting back against a bully.
Right.
Oftentimes bullies pick on someone else, move on. Once someone starts punching back. So owners come to us even for the inspection when they're tired of being pushed around. They don't like the answers that the association is giving them. And you said gamesmanship. I think that's a great way to put it. It's a nice way to put it. I could use some other choice words.
I'm sure you can.
But, I think once they receive the notice of representation with the records inspection, they know they have to confront the issue. There's no more hiding. There's no more delays.
The gig's up.
Yeah. So they have to confront it.
Okay. Well said. All right. I think this is a good time.
I have a couple questions. Number one, we've talked about condo associations. Is this apply to homeowners association as well? Because I know there's two different laws, one for condo associations, one for homeowners association. Is the same laws that we're discussing, are they applicable to both?
Yes and no. It's a little bit different, but same mechanism. Homeowner associations have the same statute that demands transparency, similar in co-ops as well. But the scope is a little bit different, as well as the record keeping. Because when you get into condos, you have to worry about size of the condo, the units. When you're dealing with homeowner associations, you have to deal with the number of lots and so forth. But the general idea of demanding transparency is in homeowner associations, co-ops, recreational vehicle parks. So it's a great mechanism to understand, how your money is being used. I mean, for all these associations and protecting your investment.
So in other words, it's the same. The laws are, it might be different statutes, but it remains the same, that you're still entitled to some documents, some specific documents, and you can request them by the mechanisms that we just outlined.
It sounds like the spirit is alive and well in all of these different associations and formations.
Absolutely.
And then,
the state of Florida wants you to be able to keep your board in check and, act like almost policing them on behalf of Florida, so they don't have to get involved and worry about, all of this. It's kind of, up to the owners to find out what's going on behind the scenes, and the associations can't hide from it.
That makes sense.
David, tell me, we referenced it a few times, and I assume that's where we're heading, is you referenced a new law that you said about like digital record keeping. And I want to just do like the 40,000 foot view and just kind of unpack that before we get closing to wrap this thing up.
And hit you with the Reddit.
Yeah.
Yeah. So basically, as I mentioned, the record keeping can be really inconsistent. So starting in 2026, it's codified, last year, but give associations some time to get up to speed. They have to digitalize their records. So basically, they have a website, and some already do, of course. Basically, they have to have a website that is open to the public, but a member section that is password protected. And on the website, they have to have the records that are available, during the inspection, just maintained on the website. So instead of taking time off work, flying down here, whatever, you can just have a few clicks, enter your password, and see the documents that you're after, you want to see. That doesn't mean to put everything on there, but they have to put the bulk of what's already codified, on an online portal.
I love that.
Yeah, I mean, it's 2026 by that time. It's
but it
taken a
removes
while.
that. What I love about that isn't the fact that it takes the logistics out of it. It's that it removes the potential games. The one thing that drives me nuts as a homeowner, and that has lived in an association before, is the potential for gamesmanship, particularly when you're dealing with a meddler or a tyrant that just doesn't want to work with you.
Assuming everything is uploaded and is available.
Of course, we do understand that, but at least it has some teeth now. The law states it, and you can't say, well, the records are down here in Miami and you live in Orlando. Man, that's a bummer. And we're available tomorrow at 9 o'clock.
It removes some of that.
Yeah, it just gets rid of a lot of that nonsense.
No, I think it's great.
Yeah.
I think it's tremendous.
Yeah.
Florida is really doing the right thing in a lot of ways, in my opinion.
Yeah, I think it's mutually beneficial. I think it's great for associations. It's easier for them to maintain records, to keep records, to have it one click away as well. I mean, it'll take some time to get used to, but I think it benefits everyone.
Agreed.
So, looking forward to all the associations, getting up to date. I might have to spend a little money to get a website or having someone to maintain it, but in the long run, I think it'll work out for everybody.
I agree.
Well, this is really helpful information, actually.
I agree. I thought this was a wonderful topic. All right, let's do Reddit. I think we have time for the Reddit rapid fire. Yeah.
All right, David. So, you don't know. So, one of the staples in the podcast is usually at the end of the episode, just to break it up a little bit. We go on Reddit. We find there's plenty of subreddits of people that have a bad taste in their mouth when it comes to their HOA. They post very spicy topics.
They're easy to find.
They're easy to find, and I always thought it's fun to throw it at either Luke. Luke's gone through
countless
20 of these things.
There's been a lot.
Jeff's gone through them. Chris has gone through them. It's just a fun way of just throwing something random at you and just see what your take is on it. So here's HOA towing help. Here we go. In my condo complex, as a homeowner in Florida, I parked my car in a lot on the property by the pool alongside 8 other cars around 9 p.m. at night. I have multiple cars, so there are 2 in my driveway, and I needed the extra spot for the car for a few days. 10 days later, my car is missing. I called the HOA, and they said it had been towed for, quote, overnight parking in a pool area, end quote. I was confused because many cars park there overnight, and there's nothing in the bylaws against that. I called the towing company and they said the same thing. They said there was no rule and they would call me back. Then they said they, quote, remembered that my car was actually towed because it was considered an abandoned vehicle for having 4 flat tires. I don't know what to do. My HOA has fined me, and do I have any recourse?
So I think this is a great example for getting more information. And participating in the records inspection request process. First, I'd ask for the contract between the towing company and the association. Is there a relationship there that motivates either party to tow?
Potential kickbacks.
Yeah. So are they quick to tow in the situation because it's financially beneficial? Second, of course, if he doesn't know the rules, ask for the current rules. Whether that's contained in the covenants, or some other rules, the association is tasked to maintain the most up-to-date information of the governing documents. So if you're breaking the rule, you're breaking the rule. But you first need to know if there is such a rule. And if there is a rule and you are breaking it, but you're not the only one, but the only car got towed, well, then you may say this is selective, like I'm being picked on, selective enforcement. So in that case, you want to see, all records concerning cars that have been towed from this property. Cast a wide net. How often do they do it? Is it only in the pool areas, other places, or am I the only one in the past 5 years yet? I know other people are parking by the pool or, whatever abandoning the vehicle is, on the property. So you investigate to determine, did they have the authority to do what they did? If so, have they done it before? So you're trying to find out, do you have any recourse? So you might, depending on what you find, but it's always good to have more information so you can be calculated with your next approach.
That was a great response, and I loved how you tied it into record inspection.
And that was not intentional.
Yeah,
it just so happened that was serendipitous.
I think it goes back to knowledge is power, and really this podcast opens up an avenue to get that knowledge, and really force a board and compel them to give you what you're entitled to. Yeah. So, David, I cannot thank you enough for being on the show. I thought that was fantastic. Marty, I think this was
a fun one.
Yeah,
this was a fun one, and really good information about that you have a right to these things, and and just having the mechanisms explained and how to do it really helps the homeowner on the other side. Because I think a lot of this stuff just goes down to is ignorance. They don't know.
Agreed.
And that just breeds frustration. So this is, I think, another great tool that the homeowner can use to leverage in order to get these bad HOAs under control.
Understood. David, thank you so much for being on the show.
All right. Thank you both so much. I appreciate it. It was a fun time.
And keep fighting the good fight in Florida.
Will do.
All right.
And comments.
Yes. Thank you guys for watching. Please leave us several comments. We love the comments, and
if
subscribe.
you have any specific questions for David, that's not legal advice. Leave them there, and we'll put them in front of him as well.
Very good. All right, guys. Thank you, and until next time.